Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys, with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Good evening and welcome into the attorneys. Thank you so much for joining us tonight. For the next half hour, we have a panel of experts here with us, ready to deal with an issue that we believe will be interesting to you. The way this works, if you are new to the program, first of all, welcome. Second of all, information will be scrolling at the bottom of the screen all throughout the evening, ways that you can interact with us. Also, the law firm of Hollis Wright, they make available attorneys right now standing by live to take your call. That's off air, completely confidential, not something you're going to hear here on the air, but if you would like some free legal advice, Hollis Wright makes that available all throughout the program, so just pick up the phone and give them a call. Leading our conversation, managing partner of the firm Hollis Wright, Josh Wright. Good to see you, sir.
You too. How's your week?
It was all good.
Back for another fun-filled show, Dave.
That's right. We have another interesting show that affects a lot of people.
Yeah, so sometimes we do shows that overlap a bit with other shows we've done in the past, but we'll bring new guests on that will put a new spin and focus maybe on different issues that we didn't focus on before. And a lot of times we'll get questions that kind of form the next show in a kind of an original show. So today we're going to be talking with Cedrick Coleman from the May Legal Group here in Birmingham, actually president-elect of the small firm section of the Birmingham Bar Association.
Correct.
And we're going to be talking about landlord-tenant issues. And there are a lot of folks in our viewing audience that will be impacted by this show. So we're going to answer some common questions that people have related to the landlord-tenant relationship, and a little bit about what you can do to protect yourself when you're getting into a lease agreement, or if you're a landlord and you have a tenant come into your home. So we're going to be talking about that stuff today. First of all, welcome. I'm glad you're on, and super excited to have you on. Tell us a little bit about this area of the law, because it's kind of a specialty. I mean, not everybody does landlord-tenant-based law. You have to know the statutes, have to kind of understand the law. How did you get involved in it?
Well, a lot of tenants or people who come with us for other issues have issues regarding their housing, from first-time landlords to a tenant who may have missed a month of rent. So they've asked to look into it, and that actually expanded my role into it.
So tell me this, May Legal Group, how many folks do y'all have, and kind of what is the specialty of that? Is it a broad practice?
It's a broad practice group. There's 4 attorneys. We specialize from anything from criminal to civil litigation to bankruptcy and all between.
Kind of full service shop.
Absolutely, one-stop shop.
All right, so let's dive into this landlord-tenant concept. Is there a statute in Alabama that kind of governs the rights and responsibilities of landlords and tenants? How does that work in Alabama?
So the Alabama Landlord-Tenant Act, it actually covers residential leases, and it responsibilities of both the landlord and the tenant of things they must do based on the lease.
Talk for just a minute about the importance of a lease agreement and why someone would need to have a lease agreement. Because I'll tell you this, you and I talked before we started the show today, that in my world, I sometimes will deal with landlord-tenant based issues because of litigation associated with landlord-tenants, fires, those types of things. And lease agreements are always super important whenever I've got my case. Talk just for a moment, a little bit about the importance of lease agreements.
Basically, it dictates who's responsible for what, from the maintenance, the upkeep, and everything in between. Landlords have a minimum responsibility to keep the apartment or house habitable. That could mean that they're responsible for the major things such as the plumbing, the roof leaking, things like that. The tenant may be, depending on what the lease says, could be responsible for the day-to-day, like changing light bulbs, filters, smoke detectors, things like that. So if the lease is silent, the Landlord-Tenant Act will take up any areas.
You know, David, you and I have actually talked a little bit about this, about some of the cases that my firm handles in the smoke detector world, where we're involved in litigation where smoke detectors have contributed to injuries with people if they're not updated, if there's not a battery in them, if they're not hardwired, if they're not working, those types of things. And lease agreements become so important in those cases because a lot of times those lease agreements will define the terms of what the landlord's supposed to do with reference to the smoke detector and what the tenant's supposed to do with reference to the smoke detector. So it's an important concept.
You know, this is the timing of this is interesting. I have a brother and a sister-in-law that downsized, and they moved into an apartment, and she was telling, and tell me if can they do this? Like the repairmen just showed up at their home, and so she ended up coming home, and she opens the door, and these guys are there working. They've given no warning, no idea or anything. There's two guys that she does not know, just an awkward situation for her, didn't know what was going on. Do landlords like that, do they have to give some sort of heads up?
They have a responsibility to give 24-hour notice for any maintenance or let the tenant know that they're coming into the apartment, because the tenant has the right of quiet enjoyment. And any landlord who makes undue or unruly commitments to time to the unit is violating that.
Okay, so they should have gotten a heads up on that.
Well, yeah, and that would be uncomfortable. I mean,
Sure.
if you think that you're protected in your place, you lock the door and it's protected, and it turns out that they can get in there. So I could see where that would be a little unnerving.
Yeah.
Talk to me about this, because this is a question we get a lot when we run a show related to landlord-tenant related issues, and that is this: if I have time left on my lease agreement, and I'm, say I've got 9-10 months left, can the landlord terminate that agreement and get the tenant out earlier than the term is supposed to end?
Yes, they can. With a 30-day notice, a landlord can terminate a lease. That gives the tenant time to find a new place, give them any option. If the landlord has other properties, they may even offer to move them into that unit. But yes, with a 30-day notice.
So is that going to be dictated by the lease agreement itself, or is that just a state law? Meaning, if you and I negotiate a deal and I put in there, we will give 90 days notice before we can kick you out or terminate the lease agreement. Does the lease agreement govern, or does the law of 30 days govern?
The lease agreement would govern, because the landlord tenant is the minimum standard.
Okay.
If it's a negotiated between the parties of 90 days, that would be the minimum requirement.
So ultimately, that's one of the issues I guess a tenant needs to make sure they look at in their lease agreement. Even though they think they may be in there for a year or 2 years, they need to assess what the termination or early termination clause is.
Correct. And from not only the tenant's, the landlord side, but from their side as well. If they need to leave the lease early, they need to see what their requirements and responsibilities are.
This topic affecting a whole lot of folks. Some good questions we've got. Question here: what happens if my rental home is up for foreclosure sale? Do I still owe rent?
Yes, you do. If for some reason the owner of the property is being foreclosed on, you still have a lease agreement, and that lease agreement will need to be fulfilled to the entirety. Now, if it is actually sold, the bank or a representative for the bank, such as their attorney, will contact the tenant to tell them, where to send rent to. But until they're told differently, they would pay it to the same parties.
So ultimately, the agreement still governs.
Absolutely.
Talk to me for a minute about military folks that are either non-active duty, about to go to active duty, or those that are active duty that have to transfer from location to location. Are there some special provisions associated with those individuals that give them some rights to allow them to transfer from place to place?
Yes, there is. The Service Member Relocation Act. It governs active duty military or even reservists who have been called up to active duty for a minimum of 90 days, or their permanent location or job site is being transferred. Just giving the landlord a 30-day notice, and they were able to move without penalty.
That's nice for those folks that really don't have a lot of control over where they're going to be transferred, for example, or if they're going to be called into active duty. I know we're getting ready to go to commercial break. When we come back, I want to talk just for a little bit about some tricks of the trade from Cedrick's perspective on what a tenant should try and do when they're looking for a lease agreement or looking for an apartment, and some of the things you need to look for inside that lease agreement to make sure you're totally protected.
That's good. Look forward to that. We'll pick up right there whenever we return. Our first break of the evening. As we head to break, a couple of reminders. You can see how you can join the conversation. Love hearing from you. Also, the firm of Hollis Wright on Facebook as well as Twitter. Just search the term Hollis Wright to find them. The firm on Facebook and Twitter, it's Hollis_Wright. Plenty of ways to keep up with all that's going on at Hollis Wright. Stay tuned. We're coming right back.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into The Attorneys. Thank you for being with us tonight. A reminder, there's attorneys from Hollis Wright standing by right now to take your call. So if you want some free legal advice, it's just a phone call away. So pick up the phone and give them a call. Josh Wright, managing partner of the firm Hollis Wright. A couple of congratulations are in store. We just wrapped up a really cool contest that you guys did, giving away a couple of iPads. So we want to say congratulations to Jennifer Lackey and Michael Sawyers.
That's right.
They are the two winners of the iPad. Hundreds of folks. This contest kind of took off. It was the like and share contest, and we had hundreds of folks joining in and participating. A lot of excitement, but congratulations to Jennifer and Michael.
Absolutely, and then there were 3 other individuals that won gift cards. And the whole concept of the show, first of all, let me just say this. It was kind of cool to do a Facebook Live. It's the first time that our firm had ever done a Facebook Live, and we gave away the iPads and the gift cards. And of course, the contest was a like and share contest.
Right.
And the goal and the focus of the contest was really to expand the breadth of our Facebook exposure to the world, if you will, because we answer a lot of legal-based questions on Facebook. And so we had lots of folks that had liked the show in the past, but we wanted more people to recognize, hey, if you come to Facebook, and a lot of people use Facebook, and you have a legal question, you can come straight to us there and we can get that answered for you. Yeah. And so that was kind of the whole focus. I think it was a wildly successful giveaway that we did. Yeah. Super excited to be able to give those iPads away and the gift cards away to be able to help folks.
And just if you did not participate in that and you do not like and you have not liked the Facebook page for Hollis Wright, go ahead and do that, because there's another contest coming up that's going to be, it sounds like it's going to be a pretty neat giveaway. So you're going to want to like that page.
Yeah, I agree. There's going to be some cool stuff coming up in the future, and we'll do something that takes the iPads to the next level, which I think will be a lot of fun. All right, Cedrick, back to our topic here. When we went to break, I kind of teased the break with, I want to talk about tricks of the trade and things that a tenant should look for when they're searching for an apartment, kind of special things they may need to look for, or things they need to negotiate in their lease agreement. Help us with that.
Okay, for starters, they want to do a full walkthrough of the unit, checking all the drains and faucets, making sure the water flows properly, drains properly. Look for any signs of water damage along the window edges or along the roof. Also flush your toilets, make sure there's no exposed wiring, all the lights work. And if anything is a default or any problems, you have them fixed. Make sure they're fixed prior to the move-in date.
All right, so if there are issues that you're aware of on the front end, let's say there's water damage somewhere, or there's a toilet that's not working correctly, do you recommend that somehow be put in writing to the landlord, or how does that work?
So if there's time before the move-in date, you just speak with the landlord and have them do it. But if you're up against your deadline of moving, you have it in writing saying that both parties understand this needs to be fixed and a time frame of when it will be fixed.
And so, David, there are a couple other things that I would also recommend, and that is always check your smoke detectors when you go into the apartment. You're at least going to have one in most apartments, if not 2. By code, there's a certain number that are required based on space and how many bedrooms, etc. And also look for fire extinguishers. The law doesn't necessarily dictate that there be a fire extinguisher in every single apartment, but there shall be a fire extinguisher within, I believe it's 75 or 65 feet from the front door of each location. And you want to know that that is there and present, because I'm a big believer that apartment complexes, and Cedrick, you may disagree, but apartment complexes that are maintaining safety-related issues like smoke detectors, fire extinguishers, etc., those are folks that are generally doing it the right way, and they're managing those very important details for their tenants. And that's one way to look and determine that a landlord is doing it kind of in the right direction. Doesn't mean they can't do some other things bad, but they're dotting the I's and crossing the T's on some of the safety-related issues, which I think is a good thing.
Yeah, me too. Hey, we've been talking a lot about the tenant side. How about if we kind of transition to landlord? Because we've got a question from someone who is a first-time landlord. And it says, I'm a first-time landlord looking for any advice, Cedrick, that you can give them. So either an apartment or a house now up for rent, any tips you could give them to kind of prevent some headaches maybe?
Yeah, absolutely. That's a very good question, because a lot of landlords are not big property owners. They own one house or one duplex or something like that. So they're not big time and who are familiar with all the regulations. First thing I would suggest is have a written contract that spells out the duties for not only you, but for the tenant as well. When rent's due, when it's late by, things like that. Let it be Alabama specific and specific to your apartment or house. Don't just go out and just get a form. Even if you start there, you need to narrow it down and tailor it to your specific needs. Secondly, I would suggest using some kind of tenant screening service. And if you choose not to do that, doing a background check, a credit report, and also some type of residential history references could save you a lot of headaches along the line.
What is the tenant screening service? There are services out there that evaluate tenants to determine whether or not somebody's credit worthy and all those other things?
Correct.
And can you, do landlords have the ability, this is a question we get, do landlords have the ability to discriminate based on race, gender, sexual preference, religious preference, any of those things?
No, that's a violation of federal law to discriminate based on any of the protected reasons.
And if you feel like, and I know we're getting ready to go to break, but just let me hit this. If you feel like you have been discriminated against, do you recommend getting to someone like yourself that handles these type of cases to have that evaluated?
Absolutely.
Okay. When we come back, I want to talk about this, because this is where it all goes, and that's this. Everything sounds great on the front end, and the lease agreement is entered into, and you're rocking along in the lease, and then something goes wrong, whether it's a maintenance issue or a safety issue or something else, and you need help, and the landlord doesn't want to fix the issue. What are your rights, and what can you expect, and what responsibilities do you have to stay inside that leased apartment if that happens? So let's talk about that when we get back.
That's a good place to take our break. We'll take our last break of the evening. A reminder to you, a few minutes remaining, if you want to join our conversation. Also take advantage of the attorneys standing by live. We'll be back. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright. If you've ever served on a jury, you may have wondered why there are gaps in the evidence you're given at trial. In today's Legal 4-in-1, we're answering the question, is there insurance to pay the verdict? Know this, just because the lawyers never mention insurance in a trial, it doesn't mean there is not insurance to pay the verdict. Rule 4-in-1 of the Alabama Rules of Evidence states this: evidence that a person was or was not insured against liability is generally not admissible or allowed to be discussed at trial in front of the jury. The reason for the rule is simple. A jury could award more money in a case if they knew the defendant had insurance to pay for it. But the reality in our state is this: in almost all lawsuits that get to a trial, insurance is there to pay judgments awarded by the jury. For example, all automobiles in Alabama are required to have liability insurance. Coverage can range from $25,000 up to $1 million in these cases. In theory, all car crash cases that get to trial should have insurance available to pay any verdict awarded in the case. Trucks have to carry anywhere from $750,000 to $5 million worth of insurance. Unfortunately, you'll never hear that during the trial. Even in medical malpractice cases, the doctor has liability insurance to help pay a judgment. That's something you won't hear during trial because the rules just don't allow that testimony. Yet almost all judgments against a doctor involve liability insurance. Please remember your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our promise and pledge to you.
Welcome back into the Attorneys Hour final segment. Just a few minutes remaining if you want to join the conversation or take advantage of that opportunity to speak with an attorney from Hollis Wright live. Josh?
All right, so when we went to break, one of the things I wanted to talk about in this last segment is what happens if something goes wrong. We saw the firm fact coming in that there's a whole unlawful detainer area of this law, which is when a landlord is evicting a tenant out of the apartment. What are the parameters of what a tenant has the right to and doesn't have the right to if something goes wrong?
Okay, so if, from the tenant's perspective, if the, say, apartment isn't being repaired in a timely manner, put it in writing to the landlord, and they have 14 days to make the repairs. The tenant cannot withhold rent during that time frame, and they can't go out and make the repairs and reduce the rent based on those repairs. But they do, however, have the opportunity to move out without penalty if the landlord refuses to live up to their obligations.
All right, so let's take it a step further. Are there certain things that qualify as health and safety related issues, structural issues that are more important than small issues like, hey, my toilet continues to run, that's one issue. The other is my smoke detector is not working, or there's a structural problem, the ceiling's caving in. Does it matter? Does the 14 days still apply, or how does that kind of work?
Well, as long as it goes to habitability or it falls under their responsibilities under the lease. Toilet still running could be an issue that even actually could lead to them being able to move, because if they're paying the water, that running water makes their bill go higher, and it's costing them money.
So if you put it in writing and then you delay and wait for that 14-day period to run, and the landlord does not fix that, you have some rights at least to be able to consider moving out.
Yes, I would consider it. Highly suggest speaking with an attorney at that point to see what your options are and the best way to facilitate an exit from the apartment.
Do you find a lot of times people come to you after they've made a rash decision because they're frustrated with their landlord and now they're in a legal jam like an unlawful detainer because they didn't go to a guy like you in the first place?
I find that on both sides of the issue, where a landlord has made comments such as, I'm going to change the locks, and the tenant moved, and then they're looking at a constructive eviction suit against them. So yes, making rash decisions on either side is not a good thing.
We talked a little bit about that, or we didn't, but it was on the firm facts, the unlawful detainer. Can you just generally outline unlawful detainer? And I'm not necessarily talking about all the time frames, just in general kind of how that process works and how the landlord has to file certain things. They can't just come in one day, knock on the door and say, you're out. They've got to follow the law.
Absolutely. The self-help method of prior to 2007 is gone. Okay. Just sticking someone's property outside. You have to go through the courts if you want to remove a tenant who is no longer lawfully due to stay in the property. So following with the courts, waiting the allotted time, going to the courts and asking for the court's permission to have them removed. It is a step-by-step process that must be followed.
Another question we've got here, just a few minutes remaining, we want to fit this one in. What happens if I am served with eviction papers? Any advice there?
Yes, the first thing you should do is contact an attorney. You have a very short window to reply to that. It's 7 days from the date it's received. And if you don't, you will be considered in default, and the landlord can proceed with the eviction process. Now, you need to respond stating that you do agree or disagree with what the amount or the terms of the eviction are requested.
And a lot of times in those unlawful detainer suits, the tenant can be in a circumstance where not only are they paying the back rent, but they're paying interest and also paying the legal fees. Is that right?
That is correct.
So that's something definitely a reason you want to go to a lawyer.
Absolutely. And if you are actually in default, there may be ways to cure, and the landlord, or their attorney, may be willing to negotiate the terms of that cure.
And you talk about cure, and I know as lawyers we know what that means, but just kind of define that issue. What do you mean by cure?
Cure meaning to make the default go away. So for instance, if you were 2 months behind, you may have an opportunity to repay that 2 months of rent. Maybe not all at once. They may be willing to negotiate where it's paid over the next 4 months as part of your rent.
And have you found, I know we're getting ready to wrap up, let me just end with this question on my end. Have you found that the courts and the judges in Jefferson County will work with a tenant that genuinely wants to stay in an apartment to try and allow them to negotiate with the landlord to continue working forward? Or do they follow the unlawful detainer process pretty specifically, and if you can't cure completely, you're out?
I'll say that our judges follow the law completely. However, they will allow for the landlord and tenant to work through their issue before rendering a decision. If there's any way that they can actually continue with the lease, they'll give them opportunity to make that work.
So sometimes you want to make sure that you've got a good relationship with your landlord, for better or for worse, because you may need that relationship down the road.
That's good advice. Just less than 2 minutes remaining, but want to get a final thought from the both of you. And Cedrick, if you would, you go first, please, sir.
It's vitally important for all people to read your lease. Make sure you understand what your responsibilities are and your landlord, and vice versa, your tenant. Never just sign an agreement without reading it thoroughly. And if you need any help, please contact an attorney.
You know, this is, I'd just say this is a little bit complicated area of the law. A lot of times we're talking about just basic civil cases that are pretty easy, where you don't always have to go to a lawyer first. This is an area where if you get yourself into a jam, or even before you get to a jam, if you recognize you're about to get there, you need to come to a firm like us so we can get you directly to Cedrick, or go directly to Cedrick. But if you don't remember Cedrick on the show, come to us. We'll get you allocated to a guy like Cedrick Coleman. Because it can get complicated, and what happens is people get themselves in trouble by not using a lawyer that could have solved their issue on the front end. Simply sending a letter saying, look, this person genuinely wants to stay here, but we need to renegotiate this lease just a little bit, and here's what they can do on a bi-weekly basis, for example. And so sometimes being a little proactive by having a relationship with someone like Cedrick on the front end will help you on the back end. And the last thing I'd say is this. I do a lot of smoke detector litigation. Make sure you check your smoke detectors once a year if your landlord's not doing it, because that can be a very, very dangerous issue for you and for your family.
Absolutely.
Thanks for
good
being
advice.
on. Good job.
Thanks to both of you, and thank you for joining us as well. Really helpful information tonight. Hope you enjoyed it. Here's how you can continue to get in touch with the firm of Hollis Wright, and certainly how you can keep up with them on Facebook as well as Twitter. Thanks so much for being with us. We'll see you next time on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.